Microsoft and ValueLicensing are back in court. Microsoft secured an extended stay while it seeks Supreme Court permission to appeal. The claim is for £270 million. The issue: can perpetual on-premise Microsoft licenses be resold or subdivided from the register? ValueLicensing filed suit in 2021. The Competition Appeal Tribunal ruled in 2025 that resale and subdivision did not infringe copyright. Microsoft lost in the Court of Appeal in early July 2026. On July 21st, an extended stay was granted, while Microsoft seeks Supreme Court permission. Disclosure and confidentiality applications may still be considered in September. This is a procedural but strategic update. Microsoft shifted from a contractual argument to a copyright-based argument. The Tribunal and Court of Appeal rejected the copyright claim in this case. The stay pauses the liability trial while Microsoft seeks leave to appeal to the Supreme Court. The dispute hinges on perpetual versus subscription licensing. Perpetual licenses grant ongoing use rights. Resellers say surplus licenses can be resold or subdivided. Microsoft argued contractual limits and then copyright restrictions. The register references the Usoft precedent that limited vendor control over resold licenses in the EU. This matters because it affects procurement flexibility and cost choices. Allowed resale could let organizations recover value from surplus on-prem licenses. That would influence CapEx versus subscription decisions. For now, legal uncertainty and possible disclosure requests may affect procurement and audit processes. The register references Usoft from 2012, which limited vendor control over resold licenses in the EU. The tribunal noted oddities in Microsoft's approach, including distinctions for physical media like CD-ROM. The outcome will depend on UK law and current contractual wording. Editorial analysis: if resale and subdivision become practicable, secondary markets for enterprise licenses could expand. Procurement teams might recover value from decommissioned assets, and smaller organizations could access subdivided license packs. These outcomes depend on legal clarity and logistics. Key limits: the stay pauses the liability trial, but does not freeze disclosure or confidentiality applications. The tribunal's finding was fact-specific, and other cases might differ. Contracts, audits, and logistics would constrain adoption even if resale is allowed. Editorial analysis: impacts on developers and independent software vendors are likely indirect. Changes in enterprise procurement for productivity suites and server licenses can affect vendor pricing and predictability. If resale becomes common, clearer license transfer processes may be needed. This is editorial, not stated in the source. Systems teams could see changes to audit schedules and asset retirement policies. Retired servers and desktops might be treated as potential resale assets, but legal uncertainty may cause organizations to delay resale until rulings are final. Watch these dates. ValueLicensing filed in 2021. The CRT ruled in 2025 that resale and subdivision were not copyright infringement. Microsoft lost in the Court of Appeal on July 7, 2026. An extended stay was granted on July 21, 2026. A September case management conference will consider outstanding applications. Bottom line: this is a legal dispute with commercial and operational implications. Systems, procurement, and legal teams should watch the Supreme Court permission decision and the September case management conference. A final ruling could change how enterprises buy and monetize perpetual software licenses. This report is based on the register's coverage. See the source link in the description.